Welcome to Discovering the Law. My name is Lucy Rivera and I am the host of this program. This program can be viewed at www.discoveringthelaw.com. Today we have an attorney from the National Labor Relations Board, Lucy Reyes. Lucy, welcome to our program.
Thank you for having me.
Thank you for coming. So our first question will be, what is the National Labor Relations Board?
The National Labor Relations Board is a federal agency. It's an independent federal agency that enforces laws that are there to protect workers from certain conduct from employers and unions. And we also hold elections for employees to decide whether they want to join a union or whether they want to not join a union or they want to get rid of a union in a workplace.
Okay, so that's what the National Labor Relations do.
Yes.
And what is the National Labor Relations Act?
Well, the laws that we enforce are encoded in the National Labor Relations Act. And that's there's a whole set of rules that it's basically the laws that we enforce. And all the laws that protect employees from certain conduct from an employer and a union are encoded in the National Labor Relations Act.
Okay. Where is the National Labor Relations Board located?
We have offices all throughout the country. And in this region, we have an office in Boston at 10 Causeway Street in Boston, the federal building, the Tip O'Neill Federal Building. And that office covers, it's a regional office, so it covers Maine, New Hampshire, Vermont, Rhode Island, Massachusetts, and Connecticut.
Very interesting. Now, part of the things that the National Labor Relations Board do, you indicated, have to do with the unions and forming unions. Explain to the audience, how do people join a union?
Well, it's part of the laws that we enforce. Our laws that protect employees if they want to form a union or join a union, or if they want to assist a union in organizing their fellow employees, or if they don't want to do that, if they want to stay away from all that, the laws that we enforce protect that. So if employees want to form a union, they should talk to their fellow employees, see if there's support for an organizing drive, and contact a union, a labor organization that they could find online or in the phone book, if there's any phone books now. But online they can find a labor organization, or they can form their own. They don't have to join an established union in order to enforce their rights as employees.
And what is the process of forming a union? There are percentages of employees that vote on it. Would you tell us what the process is?
Well, if employees want to form a union or join a union, they should ask their fellow employees, and they can file a petition, what we call a petition, with our office, with the National Labor Relations Board. In order to file a petition, they should collect signatures from about 30% of their coworkers. Once they have signatures saying that those coworkers want to join a union for the purposes of collective bargaining, they file a petition with us we call this a showing of interest, which tells us that 30% of the employees are interested in joining a union. And there's certain things happen in my office, but basically within a certain period of time, we hold an election. And we go out to the workplace, and the employees will come out and vote. And in order for the union to prevail, they have to have 50% of the votes plus one. Not 51%, but 50% of the votes plus one, and they'll prevail. And it's of the people who vote that day. So it's not 50% plus one of the total number of employees that will be in that unit, but of the people who vote that day.
Oh, very well. So in other words, if there are 100 people, you don't have to have 50 people plus one. But if there are only 20 show up, you need 50% of the 20.
You would need 11.
10,
you
plus
would need
1, 11.
Exactly.
Okay.
But you want the majority of the unit members to vote, because if only 11 people select this and there's 100 that are working in the plant or the corporation, you really want a representative of the majority of the employees. So that's why we request that they have at least 30% of interest before we go in and do an election. It's also, we also go in and do elections if employees want to get rid of a union. So they have a union that's already in the plant, and the contract is either about to expire or it has expired, the collective bargaining agreement, and they want to get rid of the union. We go in and hold the vote. And again, for the union to be able to stay, they have to have 50% plus one in order for them to stay.
And to get rid of it, you also have to have 30%.
Exactly. You also have to show interest. And in this case, the interest would be 30% of the total unit employees are interested in what we call decertifying the union. So once they show us that there's that interest, basically we'll hold an election, and the employees will then decide on their own whether they can do that.
Very interesting. Now, what is the benefit of joining a union? Well,
there's power in numbers. So employees will know that if they want to discuss something with an employer, like something like the terms and conditions of their employment or their wages, they don't have to go on their own. So they can join other employees, and the union will go on their behalf and bargain with the employer for wages, hours, and other terms and conditions of employment. But employees don't have to join a union in order to do that. They can get together with fellow employees, and then as a group, or if there's a spokesperson for that group, that person could go and talk to the employer on behalf of others. And even if there's no union involved, we protect the rights of those employees if the employer decides to retaliate against that person or that group of people for trying to enforce their rights, trying to negotiate or bargain or ask for different wages or better terms and conditions of employment. So they don't really have to join a union in order to do that. Just the fact that they get together as a group in what we call concerted protected activities, the National Labor Relations Act will protect them in that.
And I wanted to ask you about the National Labor Relations Board. What is it that they will protect as far as concerted protected activities? What are those?
Well, concerted protected activities is when employees will get together, which we call in concert with other employees. The activities are protected because they're protected by the National Labor Relations Act. But they basically get together with other employees to ask for better wages and better terms and conditions of employment. And those are part of the rights that are protected by the National Labor Relations Act and that we enforce, the National Labor Relations Board. So it's, they have a right to form a union or join a union. They have a right to get together with their fellow employees and act in concerted action to ask for better wages or better terms and conditions of employment, and they have a right to refrain from doing all of that. That's also within their rights, and those are the rights that the board enforces.
So the National Labor Relations Board has certain actions that they protect, but what conduct is in violation of the National Labor Relations Board?
Well, for example, by an employer, if employees are acting concertedly or they join a union or they're trying to organize a union in the workplace and the employer threatens those employees with discipline or termination or layoffs, or if the employer actually disciplines those employees or fires those employees for that conduct, that would be conduct that might be in violation of the act, and we would investigate those cases. Also, by a union, if a union threatens an employee in the same way, it threatens an employee, or decides not to bring a grievance or process a grievance on behalf of an employee because that employee doesn't really support the union, that would be something that could be illegal under the National Labor Relations Act, and it's a case that we would investigate. So those are the examples of how this works. So any employee could bring a charge against a union or against an employer in my office, and it would be for conduct of that kind.
And so in that vein, how would the employee or the union bring the file or a claim in your office at the National Labor Relations Board? How would they, if they feel that they have been retaliated because of their union activity?
They can call us, and we will direct them as to how they can file a charge, or they can visit us. Our office is, as I said, in the Thomas P. O'Neill Federal Building next to North Station, and they can visit our office anytime between 8:30 and 5 o'clock, Monday through Friday. And if there is something that we believe we can investigate, we'll take a charge right then and there from the employee, and we'll conduct an investigation. So they can call us on the phone, and they can come visit our office. In order to file a case in our office, they don't need to have an attorney. They certainly can have an attorney if they want, but they don't have to have an attorney to file a charge in our office. And they can come as a group, and they can file individually and as a group against a union or against an employer. To file a charge in our office doesn't cost anything. There's no fee. And while we conduct our investigation, there's no cost to the employees in our investigation.
What is the number they can call if they want to file a complaint with your office? And you can do it by phone, or they can do it in person? If
they're in the Boston area, or if they're actually in Massachusetts, New Hampshire, Vermont, Rhode Island, or Connecticut, they can call 617-565-6700. Okay. And if they are anywhere else in the country and they have a question for the National Labor Relations Board, we have a 1-800 number, an 866 number, and that is 866-667-NLRB. So either one of those numbers will work, and if they call the general number, they will be directed to the proper office.
Very good. And Lucy, what happens once they filed the charge with your office?
If they file a charge with our office, the first thing we do is that we interview the person that's filing the charge, the charging party. And we'll take statements from the charging party and any of their witnesses. We'll take their evidence, if they have any paperwork, a letter of termination, a warning, any paperwork that they have, we'll take that from the employees, and we'll interview all their witnesses. Then after that, we present the union or the employer with the evidence that we have. And we protect the confidentiality of all of our witnesses. So even if we tell the employer or the union the evidence that we have, we're not disclosing the witnesses that we have spoken to. Then we give the employer and the union opportunities to respond. They usually have their attorneys, and they'll meet with us. We'll meet with their witnesses. We'll sometimes go out to the plant or to the union offices and interview all their witnesses. And then we'll get back together in my office and make a decision on the case. And once we make a decision on the case, we can either issue a complaint, or we will dismiss the charges as there's no violation of the National Labor Relations Board, the Relations Act.
Very interesting. So you are watching Discovering the Law, www.discoveringthelaw.com. And my name is Lucy Rivera, and we are here with Lucy Reyes, who is an attorney for the National Labor Relations Board. We're talking about how to form a union, and we're talking about the rights that the National Labor Relations Board protect. And I wanted to ask you, once the charge is filed, what happens next?
Well, after we do the investigation, and we decide, say for example, we decide that we're going to issue a complaint. We will issue the complaint against the employer or against the union, and there's always an opportunity for the party that's been charged, either the employer or the union, to settle the allegations. And but if that settlement period passes and there's no settlement, we go to trial.
Okay.
And there's a judge that's an administrative law judge that comes from the National Labor Relations Board, and they'll fly to, in our case, it would be to Boston or to Providence or in New Hampshire, depending on which part of our region the violations took place. But the judge will fly in and will hold a trial. And in the end, the judge will render his or her decision. And that decision is appealable to the National Labor Relations Board. And after the National Labor Relations Board, it goes to the Circuit Court of Appeals, the Federal Circuit Court, and from there to the Supreme Court.
Very interesting, Supreme Court. What about petitions for elections?
If there's the process usually is that the union or a group of employees will file a petition in my office, and they'll file the cards or a list of employees that have signed showing the interest in having us have an election. As I said, they need 30% of the unit as a showing of interest. Once they do that, we hold a hearing if it's necessary to decide whether the unit that they're petitioning for is a viable unit. And usually we don't need the hearing, but we could hold a hearing if that's necessary. And after that, within a few weeks, we go out and we hold the election. We bring out a booth, a voting kit, the ballots, and employees will come out at certain times that have been stipulated by the parties or that have been set by the National Labor Relations Board, and they will come out and vote.
Oh, so in order to form your union at work, you have to file a petition for an election with your office as well, petitioning that they want to form a union, and then you would do all that, and they would vote, like you said, 50% plus one to whether or not they want to form a union.
Exactly, and we usually, what happens is at the end of the election, right then and there at the job site, we open the ballot, we open the box, we divide the ballots, and we count. And by the end of an election, we know if the union has prevailed or if the employees have been successful in getting the union out of their workplace. So we usually have a decision on the same day of the election.
Okay. And have you run into any issues as far as forming unions or when that people don't want to have a union, or have you seen that?
We've seen that, and there's sometimes employees will show an interest in the beginning, and a few weeks pass, and they ask a few questions, and then they decide, well, maybe the union is not the best thing for my family. So when we hold the election, it's even though the union has shown us that they had 30% of the interest, when we show the election, it happened that it's not the case. Things could change, but that's our process is employees vote in a secret ballot fashion. So once they are behind the booth, we make sure that there's no undue influence on the way that they're going to vote, and they vote how they wish to, and no one knows how they voted.
Do you find that that's happening? A lot of unions are forming now at work.
It depends. It depends first. It depends on the time of the year. It depends on the economy. It depends. There's many things that where people decide whether they want a union or they want to get rid of a union. I think it's been pretty steady in the last, I'd say, 10 years. It's been pretty steady. The same amount of unions that we had. Before, so. And so
it's pretty steady, so you don't see maybe new unions forming in certain areas of work or certain traits?
Yeah, we don't monitor trends like that. There's, as I said in the beginning, we're an independent agency, and there are other federal agencies that would monitor trends like that. For example, the Department of Labor may have a division that monitors those trends, but we usually don't. That's all I'm saying is from what I've seen in my work.
So how can the National Labor Relations Board help the people?
Well, if employees many times don't feel that they have any power, so they don't see many times that they have power. So as I said before, there's power in numbers. So we want to make sure that employees know that if they don't agree in something that is happening at work, there's a strong likelihood that your fellow coworkers don't agree either on something that's happening at work. So if you get together with your fellow coworkers, there's strength in number, there's power in numbers. And we want employees to know that if they get together, if they demand better wages or better terms or different terms and conditions of employment, there is a federal agency that protects workers from retaliation by employers in doing that. So that's what I think is the most powerful thing that we do, is that employees can always get together with others and demand their rights. And they can't be retaliated against for doing that.
Right, and if the employer retaliates, and give us examples of that, because I'm sure there are subtle examples that is not so obvious. When retaliation means that when somebody joins a union, for instance, you should explain that. But
well,
for
example, we've had in the majority of the cases, the company is not going to say, well, you're now fired because you were trying to bring a union in. So the great majority of cases, that doesn't happen. Right. So what we see is that employees that for the last year and a half, they've been coming in a little late. So instead of punching in at 8 o'clock, they're punching in at 8:10 every day for a year and a half because they have some problems with daycare or for traffic or for whatever reason. And then they're staying until 4:10 because they came in a little later, and that hasn't been a problem for a year and a half. All of a sudden, that's a problem. So the employer says, you know what? And we have all this evidence that this person was punching in at 8:10 every day, and you have to be here by 8 o'clock, so they're fired. So what we look at is we look at the history that person had for a year and a half, showing that consistently they punched in at 8:10. When the employer says, now, well, you know, that's a problem, it's usually because of something else that now it becomes a problem. So that's basically how we look at things. We see if there's a pattern, and if there's if this type of behavior that the employee is being disciplined for is something that was allowed in the past without any discipline, then it's a problem for the employer.
Well, Lucy, I think we're running out of time now, but I just wanted to ask you for the last comments that you would like to make as far as your work, important work, maybe a little bit about unfair labor practices or anything that you want to say. We just have a minute.
Well, I think I want to make sure that everyone has our phone number. It's 617-565-6700. If you don't know whether the conduct that's happening at work is an unfair labor practice, call us. Don't hesitate to call us, because even if it's not, we may be able to send someone to another federal agency or another state agency or to a private attorney to deal with an issue at work. So even if you don't know if this falls under a jurisdiction, give us a call. There's someone available every day, Monday through Friday, 8:30 to 5, to answer public questions.
Very good, Lucy. Thank you. And to all of you at home, thanks for watching our program today at www.discoveringthelaw.com. You can follow this program again and many of our past programs. But today we learned a lot about the unions, and we learned a lot about how to form them, about concerted protected activities and unfair labor practices. And we thank Lucy Reyes for being our guest today. Thank you so much for being here.
Thank you for having me.
And for all of you, please contact me at lucinda.rivera@discoveringthelaw.net and .com. And I want to hear any comments about this program. Thank you for joining us today.